Rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court. Now sitting.
Please be seated. Good morning. Welcome all of you to the docket this morning. Excited to have all of you here. We do have some students that are going to be joining us between the first and the second cases. So I just wanted to let council know there might be kind of an influx of people at that point, but hopefully they will just give them some time to settle as we transition from the first to the second case. With that, I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the morning docket.
Thank you, Your Honor. May it please the court. The first case on the 9 a.m. docket for Wednesday, October 26, 2022 is appeal number 124625, Christopher Shelton-Jenkins versus the state of Kansas, Johnson County, briefs both sides.
May it please the court, Richard Klein on behalf of Christopher Shelton-Jenkins, present and ready for oral.
May it please the court, plaintiff appellee, the state of Kansas appears by Assistant District Attorney Kendall Kaut, present and ready for argument.
Second case is appeal number 123825, state of Kansas versus Byron K. Johnson, Wyandotte County, briefs both sides.
Hey, please the court, Joseph Adesh, appearing on behalf of Byron K. Johnson, the appellant. We're present and ready for argument.
May it please the court, appellee, the state of Kansas through Wyandotte County appears by and through Garrett Ralph, present and ready for oral argument.
Chief Justice, that includes our 9 a.m. docket.
Thank you, Mr. Shima. At this time, I will call 124625, Christopher Shelton-Jenkins versus state of Kansas. Come forward to take their place. While you're doing that, for the benefit of those who are visitors or watching on our YouTube channel, may not be familiar with our procedure, I will explain that the justices are familiar with the facts of the case, and with the attorneys have submitted written arguments to us in forms of briefs. We've looked at those. We've also looked at portions or all of the records of the cases that we'll hear. So we will be using our computers today as we consult those items, our own personal notes that we've made about the cases, and taking additional notes through the argument. We do all of that to assist us in understanding and processing the arguments that the parties are making to us. So it is part of the system that we will be. Also, for those, the parties are aware of this, but for those watching may not know, Justice Standridge is not with us. There's an empty chair there. He is recused from hearing the first case on the morning docket. She will join us for the second case. Her recusal on the first case means not only will she not be participating during the argument, she will not participate when the court conferences the case, nor will she participate in any part of the decision-making process in that matter. That, counsel, you may begin.
May it please the court, Richard Klein on behalf of the appellant, Christopher Shelton-Jenkins. And Chief Justice, if I could have 2 minutes in rebuttal. Mr. Shelton-Jenkins in September 2013 was charged with a premeditated murder. In the summer of 2014, he pled guilty in that case. pursuant to a plea agreement. Primarily, the main point of the plea agreement was the state would not seek a hard 50 sentence. But the facts of the case are generally that, and I think they're generally agreed on. The facts of the case were that Mr. Shelton-Jenkins' wife was living with another man. Mr. Shelton-Jenkins went to their home, waited for the man to come home and shot and killed him. And I don't think those facts are significant. The backdrop to Mr. Shelton-Jenkins' plea was that he met with his attorney 4 or 5 times. His attorney did not go through discovery with him. His attorney sent another attorney to go to his plea hearing, to Mr. Shelton-Jenkins' plea hearing. And I think that, again, the primary issue is that it does not seem that Mr. Shelton-Jenkins' attorney properly explained hard 50 sentencing to him. And though the record's clear that the court explained the maximum punishment in the case to Mr. Shelton-Jenkins before he pled guilty, I would argue that the vehicle to get to the hard 50 sentencing, particularly in the summer of 2014, was significant, and that he would need to understand that. Mr. Shelton-Jenkins' view of hard 50 sentencing was that the judge would determine that. And prior to September 2013, that would be an accurate statement. But when he pled guilty, it was not accurate. A jury would have had to find aggravating circumstances to get to hard 50 sentencing. And I believe the record is clear that he did not understand that. And that's a significant problem in both his, and I guess I should have mentioned that he filed the 1507 motion in 2018, and at the same time in his criminal case filed a motion to withdraw his plea. And I think that not understanding the hard 50 sentencing process absolutely makes his plea not knowing and not voluntary. For me, that's the crux of the issue in this case.
At the evidentiary hearing, didn't counsel testify, his defense counsel testify that he reviewed the hard 50 statute with the client? And as I understand, the district court credited that testimony in denying the motion.
So the district court did not enter any factual findings. So in its journal entry, there's a single paragraph in the journal entry that says, in essence, the court has completely reviewed testimony presented in a review of the record in its entirety, and the court finds and concludes that the defendant has not met either prong of the Strickland test. And then likewise, in looking at the motion to withdraw its plea, the court focused on what happened at the plea hearing, not what happened in the testimony. Justice, I would say, yes, counsel said when asked, did you review hard 50, the hard 50 sentencing with Mr. Shelton-Jenkins? Counsel answered, I reviewed the statute. And potentially, I would say it's an unreasonable explanation given the time period. He absolutely would have said, if he'd reviewed that properly, he would have said, yes, this changed in September 2013. It was a big deal, and we went through the changes in the sentencing.
Was that question before the district court?
That was not.
And so that would explain why there was no specific finding on that question. Would it not?
Again, I don't think so. There's no specific finding on any question.
Well, let me rephrase it.
Okay.
The argument that your client did not have the hard 50 sentencing procedure explained to him is new on appeal. Would agree with that?
In part.
So if
I-
that's the case, how is it preserved for our review?
I think that he claimed that he was, did not enter a plea knowingly and voluntarily. And I think that in and of itself, encapsulates whether he understood.
Well, the whole factual focus, and correct me if I'm wrong, as I read it, it looks to me like the entire factual focus of that claim at the district court had to do with an explanation of lesser includeds, not sentencing procedure.
Not necessarily. I mean, I think that was asked to counsel. And it was asked to Mr. Shelton-Jenkins. And when that was asked to him, I mean, there were numerous issues that were brought up. It was lack of looking at discovery. It was not understanding mitigating factors. I mean, there are a number of things, and this was part of it. And in my view, the most important part. No, Chief Justice. Thank you.
May it please the court, appellee, the state of Kansas appears by Assistant District Attorney Kendall Kaut. And sorry, my voice goes in and out some. It's been like that for about the last week, but hopefully it will preserve itself for right now. Seems the sole issue that's been focused on in this appeal is whether the hard 50 was preserved. I think it's pretty clear that it's not raised to the district court level, as Justice Wall and Justice Stiegel have asked about. Here's the 1507 motion. He raises 3 issues: ineffective assistance of counsel in violation of the 6th Amendment. The plea of guilt was not voluntary or intelligent in violation of the 6th and 14th Amendments, as well as the plea of guilt was accepted without a proper finding of factual basis in violation of the 5th and 14th Amendments. There's just nothing here about the hard 50 whatsoever. The burden is on the movement in a 1507 motion. If it's a withdrawal of a plea, and obviously these issues are kind of intertwined at some level, which is why the court rightfully, I think, consolidated these appeals. We know the standards manifest injustice, which is a very high burden. But before we even get to kind of the crux of the substance of it, it's not preserved both at the lower level, so this court shouldn't consider it. And this court has just consistently, going back to 2014, said that rule 6.02A5 has got to be followed. And that rule sets up that the appellant must specify in the record where the issue was raised. And that's just not done here. And the reason is because it wasn't raised below. Now, this court for 8 years has said that's a burden you have to meet. It's not real tough to meet that burden, but it just wasn't done here. On top of that is the issue that even if this court were to find that 6.02A5 didn't apply for some reason, and I think it will probably find that it does since it's consistently done that for 8 years, the burden is still on the appellant to explain what of the 2 exceptions would apply to raise this on appeal. And that's just not done here. When we look at those 2 exceptions, we don't have either one. This is not an issue on proved or admitted facts. I mean, clearly, from Justice Wall's question, there still is a question about what Courtney Henderson, the trial counsel, said about the hard 50, and what Mr. Shelton-Jenkins said about the hard 50. And so there's a factual dispute that rests there that appellate courts just don't consider for the first time. That factual dispute would rest on Mr. Shelton-Jenkins says 2 different things. He first says at the 1507 hearing that he was told that the jury would hear the case and the judge would determine the sentence. Now, in our brief, we say that's correct. Even though the hard 50 had been overturned in 2014 in the Soto decision, following some of the post-Apprendi cases from the US Supreme Court, that is still correct. Even if the jury finds there is an aggravating factor for the hard 50 and the balancing test that exists, the judge still has to outline and impose that sentence. That's not even an incorrect statement of the law. But the second thing is, even if you read into that statement from Mr. Shelton-Jenkins as being very broad and want to view it in the light most favorable to him, he then says later on at that same 1507 hearing that Courtney Henderson never explained the hard 50, which I think gets back to there is just an inconsistency for Mr. Shelton-Jenkins at what he's saying at this district court level. And then you compare that to Courtney Henderson, the trial counsel, and what does he say? He says, I would have gone over the hard 50 with him. That's the testimony that he's given below. So that's clearly a factual discrepancy between the two. You have a trial counsel saying, I went over it. You have the defendant saying two different things. And so that's a factual credibility determination. So that first exception that it's proved or admitted facts just doesn't exist because the facts are different at this level. The second exception would not apply either, though, because it is not necessary to serve the ends of justice or prevent manifest injustice in this case. The hard 50 was explained to him by Courtney Henderson, and not having the hard 50 explained to him doesn't make a whole lot of a difference when the facts are so brutally egregious in this case. Mr. Shelton-Jenkins waited at Brandon Holmes' apartment. He said at 15:07 when Sean Minahan, the counsel for the state, asked him, did you kill Brandon Holmes? And he said, yes, I did. And Dr. Glenn's testimony at the preliminary hearing said there were 5 gunshots at point blank range to Brandon Holmes. I mean, this is overwhelming evidence of premeditation.
Counsel, given that, what was the issue in the district court at the hearing? In other words, from your perspective, what was the claim being made?
Justice Stiegel, I believe it is just lesser included offenses. I think the 15:07 outlines that there could have been a challenge about whether the factual basis was sufficient. And then Mr. Shelton-Jenkins at the hearing even says, well, when I was at Hutch and I looked at what Judge Davis said, I realized he was pretty thorough. And so I think it is solely lesser included offenses. I think that's the only issue they've raised.
That's the issue that was contested factually and then argued to the court.
I believe it is, Justice Stiegel. And so I just don't think the hard 50 should even be considered. If it is, that hard 50 is clearly outlined with a different factual basis by Courtney Henderson. And then on top of that, we kind of get into this weird Punnett square where was the issue raised below? So did Judge Draghi rule on it? But if the issue was raised for Judge Draghi to rule on, there are cases that I think support the finding that the factual and legal conclusions from Judge Draghi are specific. And State versus Shields, which was a 22 case that came out, I believe, this summer, which is 315 Can 131, this court said, and faced with this new claim that these representations were false, the district court's resolution giving the conflicting testimony necessarily incorporates what is tantamount to a credibility determination that an appellate court is ill-suited to question, even though the district court did not make explicit findings about how much time Polyak spent reviewing the agreement with Shields. I think that matters because it's clear that if for some reason we think the hard 50 is raised, then the court should presume Judge Draghi ruled on that by making the ultimate legal conclusion. Now, I agree that puts us in a very tough world about what was raised, what wasn't raised, which is why it's pretty simple just to say the issue is not raised below. And if the issue wasn't raised below, you got to argue one of the two exceptions. They didn't do that here. This court's been clear for 8 years. They just didn't meet the burden when premeditation is so overwhelming in this case.
Well,
All right, thank you, Chief Justice.
Decline your reserve 2 minutes.
Very briefly, it's clear Mr. Shelton-Jenkins raised the issue of whether his plea was voluntarily and intelligently made. And it is not possible to enter into a plea of guilt without fully understanding how you're going to be sentenced. And the record is crystal clear that he did not understand how he was going to be sentenced.
If I can dig a little further into that preservation question, I would agree with you that if in the motion, the claim is my plea was not knowing and voluntary, there are probably an infinite set of facts that might support that broad allegation. Isn't there some obligation on the petitioner, in this case, your client, to, can he just say, oh, I raised knowing and voluntary, so I get to switch up the factual basis that supports my claim on appeal? I mean, it seems to me that you're framing the issue so broadly that you can come in on appeal and just bring a brand new fact allegation. And the problem is the district court didn't get to rule on that. Does that question make sense?
Yes, it does. I would say that it's a pro se litigant. And I think we construe pro se motions liberally. I know not all the time with 1507s and not all the time with motions to withdraw pleas. I think they're construed more liberally with motions to withdraw pleas, which was done here. And that if you consider that if he doesn't understand how he's going to be sentenced,
But the problem is we don't know. There's no, I mean, trying to view your argument in the best light possible. I mean, I think the best you can do is say, we don't know, because we didn't raise this issue below.
I think it was,
As a factual question, we didn't raise it.
but there was clear testimony about it. And
Should we evaluate that testimony and make fact findings of our own on that question?
we all know the answer to that. We all know,
Well, that's the problem that we're stuck
no,
with.
no, Justice, no.
Are you asking for a remand? I mean, I
I
don't think
think-
you asked for that in your brief.
I did not ask for that. I think that is potentially the right thing, is to remand it for the district court to make factual findings, which it didn't do in its journal entry.
Issues kind of blossom from the facts. Are we to try to ascertain any potential from facts or questions that were raised in district?
There's a clear issue of whether Mr. Shelton-Jenkins understood the hard 50 sentencing. And even if you look at his testimony, it wasn't explained to him, or it was explained incorrectly. He didn't understand it. And if he doesn't understand how he's going to be sentenced, just simply cannot enter into a plea that's knowing involuntary.
Aren't we limited? I'm looking at the transcript of the 1507 hearing, and he was represented. I'm looking at the right one because I'm trying to pull up the record, but by Christian Webb at the 1507, is that right? So,
Yes.
so he's got counsel. I mean, I realize it's a pro se motion, but you get to the hearing and he's got a lawyer. So aren't we restricted to the factual statements and the issues that are raised by counsel to the district court, as opposed to anything else that might be raised on appeal later? See what I'm saying?
Yes. And I think that all of it was raised in the whether his plea was voluntarily and intelligently made.
Questions? Thank you, Mr. Klein. Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement. I will now call 123-825 State of Kansas versus Jones.
May it please the court, Joseph A. Dash, appearing on behalf of Byron K. Johnson. I'd ask to reserve 2 minutes, please.
2 minutes.
Thank you, Chief Justice.
The appellee in the state of Kansas through Wyandotte appears by and through Garrett Ralph. That's the oral argument.
Mr. Dash, whenever you're ready.
This is a post-conviction appeal based on illegal sentence for a criminal history scoring error. This appeal centers around the proper application of case law for a period when Mr. Johnson's case was sentenced on November 17th, 2011. I'm going to skip to the part I really want to get to, and then I'll come back.
When you're skipping to that part, Mr. Depp,
Sorry.
why don't you help me understand what was the law
Oh, thank you.
on November 17th? What was it, 2011,
Yes,
when he was sentenced?
yes, just.
Williams was, had been ruled on, but the application of Williams was done differently based upon pre-1993 crimes that carried no non-person designation, and those that didn't, versus post-1993 crimes.
Yes, Your Honor.
So what was the law in place at the time of sentencing?
I would say simply enough, it was Williams. That was all we had to work with.
And Williams, that time, delineated a distinction between pre-1993 crimes, followed Vandervoort. I assume you're familiar with that. And then for crimes that were post-1993, followed the Williams in the designation of person, non-person.
Well, Your Honor, and I appreciate what you're saying, and I'm not trying to,
Essentially, that's what the Court of Appeals found.
yes, they did. And I think that let me actually, I would say, and I'm going to be completely blunt, Vandervoort is the most overblown, analyzed decision that did not say what everybody thinks it said. It said one thing. It said that the person or non-person, it actually dealt with whether a person could be a misdemeanor or a felony based on the time of the prior incident. And that's all it really said was it was an unspoken thought that when are we going to choose to use the comparable statute? And they defined comparable as more simply as the most comparable offense, which eventually got changed in Wettrick later on. We're not talking about Wettrick though. Let me go ahead and go back and do what I was gonna start with.
I'm sorry,
Maybe it'll make
go
more
ahead.
sense.
I should have
No,
interrupted.
I didn't mean that, Justice. I was just, you got me a little, got me short, but I understand why. I'm going to focus on the primary conviction since criminal history is only applied to that count. This case was a slow mover. There's 3 dates that are important here. The offense was sometime between October 8 and October 6, or October 8, 2005 and October 6, 2006, or maybe October 8, but might be a typo. But 2006 is the date of offense. Mr. Johnson was not charged for 4 years until 2010. So the statutory scheme we're talking about is what was in effect in 2005 and 2006. So that's why this became a pre-Jessica's Law case. So we're talking about a 2005 statutes. And that particular statute that we're getting into right now is 214711E in the 2005 version, which started back in 1974, I believe, is when we got that one. No, that's not right. I apologize. That's not correct. It was in effect. The 2005 version is the correct statute. 21-4711E was the reason, the way that we interpreted the out-of-state crimes. That's all we had. That's one of the reasons we have Murdoch, is because Murdoch says, well, we can't put things into the statute that aren't there. And that's one of the problems with 4711E. So getting back there, so the 2011 conviction was for rape, level 1 offense, and he received a 272-month sentence based on a C criminal history, which was uncontested, although the judge only asked the defense counsel, and the defense counsel were answered. There was no detailed question to the defendant about his criminal history, which isn't a
Let me
stopgap. Yes, sir.
just clarify that
Yes.
in 2011, part of the criminal history C designation was based upon prior out-of-state convictions pre-1993
Yes,
that were scored as person felonies, correct? And that's what you're saying, that's wrong. They should have been non-person.
correct.
But I just want to understand, that's what we're dealing with here, is out-of-state pre-1993 convictions that were scored as person felonies.
And the argument, and the argument is we're adding something to that 1992 statute that doesn't exist, a classification. It wasn't there. There was no person and non-person. It was at that time, I believe what we're talking about was, it was a B felon.
Yeah.
Yes,
Would you agree that Williams was not directly on point on this question? In other words, the actual holding of Williams did not extend to pre-93 out-of-state conviction?
I think it was more vanilla than that. I think it extended to all
Well, that's not what it said, is it? I
Well-
mean, I'm asking about the actual the facts of Williams. Williams wasn't dealing with a pre-93 sentence.
No, it was not. It was not.
So in Murdoch one was dealing with that and actually made a holding on pre-93 out-of-state sentences. Is that correct?
Yes,
Would
I
you
think-
agree with that?
Yes, I
So,
do.
so that's just a lead up to my question, which
Yes.
is, do you know whether or not there were any Court of Appeals opinions that were squarely on point on this question after Williams and before Murdoch one?
I'm not aware of any published opinions, but I mean, most of those followed Vandervoort, which I believe.
So even if they're unpublished, so that, I mean, I guess that's my question. Why wouldn't those Court of Appeals opinions, if the Supreme Court had been silent on this crucial question, why wouldn't the Court of Appeals opinions, why wouldn't we look at those to determine what the law was at the time of this sentence?
We should.
And if those Court of Appeals opinions indicate that at the time of this sentence, the law in Kansas was not to apply Williams to pre-93 convictions, then that would mean this was a legal sentence at the time it was rendered.
With all due respect, I think we're splitting hairs with the pre-93 distinction. I don't think there's that much of a distinction.
Except the Court of Appeals said that's what they did. I mean, you look at the Court of Appeals decision in this case.
Yes.
They said they distinguished between the two, and that's what they relied on, and holding that your client doesn't prevail. Because the Court of Appeals said that during this time between Williams and Murdoch, there was a distinction made between pre-1993 prior history crimes, out-of-state prior history crimes, and post. And what the Court of Appeals said, as Justice Stegall just alluded to, is that it was treated differently. That was the law, at least according to the Court of Appeals. And do you know of any cases where that holds? But that's what they said, was that they were treated differently. And what was treated differently was Vandervoort was applied to pre-1993 crimes in this time period versus Williams post-1993 prior crimes.
Well, but then I would believe that the Vandervoort Court and the Court of Appeals in this case is guilty of putting something in the statute that's not there.
But the substantive issue is not in front of us, is it? I mean, the only question is whether the sentence was legal when it was pronounced. So I think what this court's struggling with is what was the law at the time the sentence was pronounced, not whether that law is right or wrong, because we've already resolved, I mean,
obviously.
we've resolved a lot of that in our
Right.
cases, but those came later. So the question is, what was the law at the time?
I would say that the Williams was the only law that we can really look at. And I think that we look at the statute that was in place at the
But
time.
that's not how it was actually. I understand that argument. Are you making that argument in the face of the fact that actually Vandervoort was what was being applied? And you're just saying that was in error?
I will continue to say this, Vandervoort was overread and it was not, the holding of Vandervoort was very, very narrow.
Let me ask this will be my last question on this. If we assume for purpose of the question that it's actually true that the Court of Appeals, the precedent at the Court of Appeals level was to apply Vandervoort to these kinds of situations, would you agree or disagree that the district court in this particular case was bound to follow that precedent?
I would say they were bound to follow what Williams was rather than Vandervoort. So I think Vandervoort exactly
The
was
district
not.
court should have ignored the Court of Appeals precedent to do something different.
I think they should have followed this court's rulings, not necessarily any other Court of Appeals. Now,
Isn't the issue, Williams is decided in what, December of 2010,
yes,
and this sentencing is November of 2011. So the issue, plain and simple, is just whether Williams is the controlling law in place at the time the November 2011 sentence on Mr. Johnson was pronounced.
and that is my argument, Justice Miles. And I understand that each one of the three of you answering the most questions are the ones that authored these opinions. And so we have Murdoch 1, which it was your opinion, and we have, so I think we have a court that has a lot of knowledge in all of these cases, which is great.
Is
Uh,
it significant that Murdoch, the Court of Appeals Murdoch panel decision was in September of 2011? So that panel decision just,
You're getting beyond I'm sorry, Chief Justice, you're getting beyond my recollection of Murdoch. And I apologize for that. But I guess it would be significant, except for that when this court accepts a case, then the Court of Appeals decision is gone. Just like it is here.
kind of falls within that murky time period where that had not yet happened.
That's
Which presents a procedural issue because, you know, we had not granted review until May of 2012. So and probably by the time of this sentencing, it's conceivable, I didn't double check the dates, that a petition for review hadn't even been filed or
well, it would have had to have been filed. I would imagine if the decision came out.
days of the deadline probably. So.
Right. You know, this whole problem really comes because the Sentencing Guidelines Act is the most litigated piece of litigation in Kansas, litigated piece of legislation in Kansas criminal law. And why? It's a runaway train. It grows and grows and grows, and you know, we're not ever getting back to the whole point was supposed to have truth in sentencing. And every time this court makes a decision, or every time the Court of Appeals makes a decision that the legislature doesn't like, they add more. They just keep adding and adding and adding. But sometimes they're missing the places where they should be putting things. And so we have these holes, like 4711E that just doesn't have anything.
Argument from this court on that point, so.
I have made my point today, I suppose. But after Murdoch 2, we do know that the train stops on the date of sentencing or when the sentence becomes final, depending on how we look at that. I know in Justice Stiegel's opinion, you have said that post-conviction cases do not apply the finality of the case does not apply to post-conviction motions. And so in this case, it really doesn't matter because the motion was filed long after the decision, the case was final. And but we also had Williams in effect right at the time of the decision or the sentencing here. So
I need clarification.
I'm sorry, Aaron.
I need clarification on that point. I mean, I still can't get over it. I think the issue here is whether Williams in 2010 from our court applies. I guess I don't really care what the Court of Appeals was doing because that's not the law. The issue is going to be whether Williams controls, I think. Let's assume we decide Williams does not control your client's November 20 sentencing. Is there any other argument that you have you need to consider to get you where you want to be? Or does that mean that Vanderbilt's there and you're sunk?
I think that means that the Vandervoort, which I still say is being overread.
I don't care.
Okay, I'm sorry. No, I
I
don't.
think everybody's saying it doesn't matter whether certain law that existed at the time was right or wrong. It existed. The question is what's controlling, good or bad.
Okay. In the instance that Williams doesn't control, my client loses, period. But I just don't think that Vandervoort was a controlling precedent for this type of case because Vandervoort did not address that issue as part of its holding.
Well,
it addressed it in the dicta. It was assumed, but it was not a key element. It was simply part of that case that just happened to happen.
And isn't that true of Williams also? I mean, that wasn't part of the Williams holding either. I mean, in a sense, both of those cases controlled in that they were both controlling precedent. Maybe to refine Justice Biles' question a little bit, it's you know, Supreme Court law is controlling precedent, but did it answer the question?
I think that's fair. Neither one answers the question directly or completely.
Doesn't Murdoch 1 tell you that Williams answered the question? Because Murdoch 1 says this result is dictated by Williams. And then and then in Murdoch 2, we said the same thing, and in Keel, we said the same thing.
Well-
Reference to Williams' impact on the Murdoch 1 decision.
Well, Justice Spouse,
It just seems to me that if Williams controls the Murdoch 1 outcome, it's the controlling law.
that is my argument here, is that Williams actually just was the law and Murdoch just happened to say, and by the way, this hole is here. And with this hole here in the statutory scheme, we can't add things to it.
Would you agree or disagree with the statement that prior to Murdoch 1, the controlling interpretation of Williams would have been any Court of Appeals opinion?
If there was something in between Williams and Mr. Johnson's sentencing, sure, but I don't think there is. I'm not aware of it. And that doesn't mean there isn't one somewhere in there, but I don't believe there is one in that short period of time.
That's because you dismissed Murdoch 1. The Court of Appeals panel, Murdoch
Yes,
1.
yes, I didn't dismiss it.
Well, I understand, but that you would put it in the category of not controlling.
If it helps my client, I would, but at this point, I really can't do that. I can't argue that. I mean, certainly I can't say that. I'm sorry. I wish I could, but like I said, it's very murky on when controlling precedent comes out of the Court of Appeals. And while I'd like it to be precedent a lot of the times, once that petition for review comes up, we're done. Well, I won't get into my other cases, but
No, counsel, part of the frustration that I think everybody has is the advocates don't make a consistent argument. Whoever's standing at that podium is making the argument that gets the best outcome for their client. Williams and Murdoch being a great example. The state argued for the outcome in Williams.
yes,
In Williams.
yes.
And then when Murdoch comes, they said, oh no, Williams is wrong. And the lawyer on the other side happened to be the lawyer for the defendant in Williams and said, I told you guys, when you argued that principle, that this was going to happen. Right. No, and so this law is in such flux that it's, really have to get past what are good arguments and just look at, what's the law and live with it.
And this, and just spouse, I think I agree with you. And this case presents some weird situations because we have the time of crimes was in 2005. The sentencing was in 2011. His appeal didn't get docketed for 7 years. So that's 7 years of case law is what's making this very difficult to argue and very confusing. And maybe not confusing for you guys, but it's very confusing for me and the court. I apologize.
Well, the failure to docket the appeal was not your client's fault.
No, absolutely not.
But it doesn't change. I mean, still, the outcome is Murdoch 2 says the controlling law at the time of sentencing. Debate we're having now is what was the controlling
I
on
understand.
November of 2011.
And I would have to say it's Williams. There's nothing further. I'll sit down.
Thank you, Mr. Desch.
Thank you.
Rolf?
May it please the court, the state of Kansas appears with the appellee, Wyandotte County, Garrett Ralph. Judge, I'm sorry, justices, I think there are a couple things that do need to be clarified with regards to Vandervoort, because the issue does seems to be what the law was at the time of the sentence, and I think everybody agrees on that. Whether it was Vandervoort in the defense or the appellant has argued that it's overruled or it's overread overused and misinterpreted. And he said today that Vandervoort only dealt with whether or not something was a misdemeanor or a felony. Not completely accurate. Vandervoort dealt with two issues. One was he had two convictions in Virginia from 1980, one for exposure, and that was what was dealt with. He had two convictions that are very similar in statute. One was a person felony. The other one, the issue was whether it was a person felony or not. So they looked at the 2002 statute at the time to see if it was comparable. On appeal, it was conceded that it was the most comparable. So the issue was whether or not that was person felony was addressed there. And then in a second part, the argument under Vandervoort was that it shouldn't have been a person felony because when it was charged from 1996 to 2000, the state charged a range of offenses. He actually committed, in his own statements, 50 to 60 molestations. In 1996, when it was the beginning of the range, ag and decent liberties, as the statute was the most comparable, was a Class B misdemeanor. In 2000, final conviction or the final instance, it had been changed to a level 8 person felony. The problem is that the jury did not distinguish between whether or not it was a 1996 instance that arose to ag and decent liberties or whether it was 2000.
Counsel, let me sort of at least cut to the chase that I think may matter. I heard your opposing counsel, I think, concede that neither Vandervoort nor Williams actually rendered a holding on this key question of pre-93 out-of-state convictions. Do you agree with that?
The holding, yes.
I mean, certainly, this is what the bread and butter of the lawyer trade is, to argue that precedent dictates a future outcome. But if you don't have a holding that's squarely on point, that's all you can do, right? I mean, you can argue from Vandervoort and the reasoning there, or you can argue from Williams and the reasoning there. But the bottom line is we're stuck with a circumstance where in 2011, there was no Supreme Court opinion that answered this question. Do you agree or disagree with that?
I agree that that question was not particularly raised.
Well, it wasn't raised and it wasn't answered. Again, of course, lawyers can argue from precedent to say, based on this precedent, the outcome now ought to be XYZ. But my point is there was no XYZ in 2011.
I agree. There was no Supreme Court case that dealt with that. As
Do you have a case in which we talked to Mr. Dash about this? The Court of Appeals in its decision in this case said that pre-1993 out-of-state convictions, which Williams didn't apply to directly, were treated differently than the Williams scenario that had post out-of-state convictions post 1993 and applied Williams. The Court of Appeals said in this case that they were treated differently, and there's some case support for that. Do you have case support for that?
yes, Judge.
And what is it? That seems to be at least important to me. If you can point us to a case where that was the law in November of 2011.
Judge, as cited in the case that this court ruled on, State v. Adams, it was an identical case and cited the rulings in Murdoch 1-299 can at 316, then State v. Mitchell, it's at 275 P3D 931. It's unpublished Kansas Court of Appeals case. Then State v. Mims, 260 P3D
Give us
1248.
the dates of those cases as you're going.
Yes, I'm sorry. 2012, 2000, State v. Mims is 2011. And then State v. McKinney is 2010.
And those all stand for the proposition of what you're proposing, is that there was a distinction in how out-of-state convictions pre-1993 were treated.
Yes. And
That's
said
the
you said
string
state-
site from Adams, right? That's what you're referencing.
I'm sorry,
Oh, sorry. Go ahead.
I think it's the same. You mentioned, you said Adams was a decision of this court and it was a Court of Appeal. Adams is Court of Appeals decision.
yes, I apologize. I misstated.
And I think when I looked at that string site, the only one that fell before the sentencing in this case was Murdoch 1. Is that correct? Or did I miss one?
No, I believe it was the one that, and I apologize for interrupting.
I'm sorry, just to clarify my question, I meant Murdoch in the Court of Appeals.
Yes, I believe Murdoch 1 was the only one that officially came before.
I thought you referenced the 2010 case.
2010 was State v. McKinney.
And what was the holding of McKinney?
Justice Steele, I apologize. I know that it is in the
That's okay.
string site.
That's an in the weeds question, I
I
understand.
don't believe I have that one with me. But to-
And are those decisions? Because actually law prior to a mandate issue in there, does the court need to look then to whether a petition was filed triggering our rule that that would stay the mandate? At least pending a decision on whether this court would have taken a petition or denied it? Do we have to tack that time period on too?
Judge, I'm not sure on that. Either I'm not understanding your question, or I don't know if I have the information.
But
to give
is a
to you.
Court of Appeals decision controlling just once it's published? If there is a petition for review filed and under our rules, you know, the mandate of the Court of Appeals would be stayed if a petition for review is filed.
Yes, I agree, Judge. I'm sorry, Justice. Apologize.
I think what Adams pointed to McKinney, point out the difference between the handling of cases before 93 and after. And McKinney dealt with a 2002 Oklahoma conviction. So they were saying it was an example that fell after the 93. And then they contrasted that with Murdoch, which was I'm not sure McKinney helps you.
I would argue that it helps in how it was the difference in treatment that the cases were handled. As Justice Biles said, one of the issues we have is whether or not the specific question was asked. And like in Vandervoort, the specific question on whether or not pre-1993 felonies that were committed should be treated as the same as the current law. In Vandervoort, that's exactly what they did, though. While there was no question that was raised, that's specifically and exactly what they did. They looked at the 1980 Virginia law and applied it to the sentencing that occurred in 2002. Not only that, they then looked at the law that applied in 1996 when one of the offenses was, or some of the offenses were alleged to have occurred. They actually overruled the sentencing at the time and had it remanded for a lower classification, since it could have been a misdemeanor, giving him only one person felony. So at the time in Vandervoort, they did apply the statute of the out-of-state conviction and then looked at the law as it was occurring in the Kansas law at the time of the current crime.
But you know, when I read Vandervoort, there were two issues presented, okay? Issue one, is it comparable or identical? And they went to the statute and said, look, they don't have to be identical, they just have to be comparable. So this is going to be our holding. It's comparable, not identical. And then the second issue was, which we've since overruled, is that it's, you know, we're going to look at, for purposes of when to do that comparability analysis, we're going to look and see, should we use, you know, historically, they use the date of the sentencing. They said, nope, we're going to use the date of the commission of the crime. and those were the two issues presented, and those were the two issues decided, and any kind of other result that came about as a result of deciding these issues is basically dicta, right? And even then, then you have Williams that comes down later, and those, that the issues presented there were post 1993, after the sentencing guidelines came into effect. So how does that affect, even Vandervoort, really, because Vandervoort had to do with pre-1993. So I don't really understand. I'm kind of jumping off where Justice Stiegel went, and really where you and your opposing counsel are, what your points are. It's the law was really confusing, but because Williams wasn't on point and Vandervoort wasn't on point, we're looking here at an armed robbery conviction from 1992, trying to determine whether that's a person felony. It's armed robbery. And I know what we're looking at is what law applies, but really our narrow issue of what we're looking at gets to your point about the Vandervoort. So how does Vandervoort apply? Do you really still think Vandervoort applies, or you think it's clear that Vandervoort applies and isn't distinct?
I believe that Vandervoort applies in the methodology that was used to address the issues. When they used the conviction at the time, the law at the time of the conviction versus what it is at the time that he was convicted of the new crimes. They did that twice. They did that both for the sentencing, but they did it also for when he was convicted. That's how they actually looked at the law, I guess, 3 times. Two issues, but on the issue of whether it was misdemeanor or felony, they looked at the law twice because it changed during that range that he did. I would argue that Williams was, you can argue, was controlling law, but it was not on point to what the issue was here. Williams addressed on the factual basis was simply post 1993. It happened to be a post 1993 conviction, 2001, 2002, and said, no, we're going to go with what the law is at the time of the conviction.
Counsel, let's say that this district court judge gets this question in 2011. What am I supposed to do? Is this person non-person? So district court judge says, I want to call a recess. I want to go do a little research. And judge goes back in his chambers and types in some stuff, and up pops Williams, Vandervoort, and the Court of Appeals opinion in Murdoch 1. Which case should the district court judge have followed?
Murdoch 1, if it occurred after Murdoch 1.
Well, we know all
Supreme
three.
Court.
No, we know all 3 of those opinions were filed and available.
Right.
Williams, Vandervoort, both Supreme Court opinions, and Murdoch 1, Court of Appeals opinion. And that's what the judge is looking at. I mean, this is the question. How is that district court judge supposed to know what the law was?
We'll look at both Vandervoort and Murdoch 1, the Kansas Appeals opinion, because it was on point.
And only one of those 3 opinions addresses the issue squarely.
Squarely, Murdoch 1 addresses the issue, correct. And Murdoch 1 says, this is how we've been treating it, and this is how it's going to be treated going forward. That was later overturned by this court. But at the time, that's what the law was.
Well, and the Murdoch panel did cite to other panel decisions that have preceded it, but they're all unpublished. And so we have both the Murdoch panel and these other panel decisions are all unpublished Court of Appeals decisions. So we don't have, I don't believe, I haven't seen a published Court of Appeals opinion on point. Have at least 3 unpublished Court of Appeals. Let's say, you look to see if they're comparable. What would the comparable classification now in effect be? Now in effect being the time of sentencing. That time we classified it as a person or a non-person.
Correct. Did you? Apologize, Justice, Chief Justice. Were you asking me a question there, or
I was just.
Or
I
just
think-
explaining what everybody should have realized what the law was or what that judge should do.
No, good point.
Okay, just making
I
sure.
think she's telling us we should.
I- And I liked what you
I
said,
guess,
so I'm not gonna say much.
I
but
guess my question would be, what do we do with the fact that they are unpublished opinions? We do not have a published opinion.
The fact that they're unpublished means that they're persuasive. And to correct an illegal sentence, the sentence would have had to been against what the law was at that time. There is nothing to say that the law wasn't what the district court ruled and what the district court sentenced. Maybe unclear based on your interpretation of prior cases, but there is nothing to say it was an illegal sentence at that time.
Then what do we do with the statements from this court that I mentioned to defense counsel, where this court said Williams 1 controlled the outcome in Murdoch 1, and then that was repeated in Murdoch 2 and Keel as being the controlling law, dictating the result. If a district court judge is sitting there trying to figure out what dictates the result that I've got in front of me,
I would contend that Murdoch 1, and the reasoning that was used, it overturned the law, as was stated by the appeal or the opinion in Murdoch, said we're overturning all Court of Appeals and district court rulings. It was a change in law.
but was it? If our court is saying in the analysis that Williams 1 is dictating the result in Murdoch 1, Williams is controlling what happens in Murdoch 1, and then we repeat that same notion in Keel and in Murdoch 2, it seems to me Williams is the controlling law coming from this court in a published opinion.
One of
What's
the
wrong with that?
one of the arguments in Williams can be argued that it was controlling, that at the time of the conviction, you have to look at what the Kansas law was. The issue becomes pre-1993, of course, there was no designation for person or non-person felonies. So then the rulings that were made by the appellate courts going up to that said, we understand what Williams is, and Williams says effect. However, it's not on point. So then you look at what the Kansas law is at the time of the new crime, whether it's a person or non-person felony. Murdoch said, no, that's not what we're doing. And we're overturning all these decisions that have come before.
Based on Williams.
Based on the principle of,
Based on Williams. I mean, I don't think you can wiggle off of that. Murdoch 1 is dictated by how Williams was decided.
I don't disagree with that. I don't disagree that it was instrumental. In fact, I believe Murdoch 1 said in its opinion that this is what we told you could happen in Williams. And that if the legislature wanted to address the issues, the difference or that 1993 was not classified as person or non-person, they can do that.
Shouldn't that be persuasive to our district court judge in November of 2011 who's trying to decide what the law is?
But at the time, they didn't have Murdoch 1 from the Supreme Court. Other questions?
Yes, you reserve 2 minutes.
Yes. I just wanted to address a couple of things. Justice Standridge, you mentioned that this is an armed robbery, and yes, it is obvious. However, we're talking about sloppy legislation that did not point out and if we're going to talk about pre-1993, and I'm not trying to be crass or anything like that. We're talking about pre-1993 comparisons. There is nothing in the statute that says, how do we compare these and what time do we compare these? And that was the problem in Murdoch. That was the problem in Williams. That was the problem. What point of reference do we compare these statutes? And what is in those statutes and what's not in those statutes? In this particular thing, nothing from 92 and below had a person or non-person designation, period. Armed robbery was the same as something that wasn't armed. Well, Armed robbery was not a person felony because there were no person felonies. Period. We came up with this in this legislation in 1993, or that became effective in 1993. And I'll be honest, I was in college when this stuff happened. In 1992, Blaine Carter came to my criminal justice class and told me, this is going to solve all of our sentencing problems. We're not going to have any more sentencing discrepancy. Black kids are going to get the same sentences that white kids do. And that was the point in 1992. That's not what's happened. Not at all. We've got just a big mess. And it's a big mess for a reason. They didn't do their homework, apparently.
You know what the difference is in what?
In this particular case, it's 48 or 58 months. So roughly 5 years on the top end. On the low end, with 15% off, it's 48 months, 4 years or 5 years. And truthfully, in Mr. Johnson's case, it may not make a difference because he might die. He probably will die before he hits that time, either one. Because he's 60 now and his out date right now is presently 2038. Make it 2035, that's 12 years from now. So
Pradesh, so I suppose, triggering off Justice Standridge's point, we're so entrenched in looking at bad or serious violent felonies as person felonies, because that's what they're classified as under the sentencing guidelines. But even if a felony is legally declared to be a non-person felony, the sentencing judge can still look at an armed robbery and say, that was really bad. That was violent. And within my discretion, I'm going to lean towards counting that against the defendant as much as possible. So you can still consider it whether or not it's classified as a person or non-person felony, right?
yes, but, and I might just say, he or she cannot change the level of a crime.
Right.
So that's the problem with our sentencing guidelines situation.
Can't change the designation of a non-person or person based
Right.
upon the act. I mean, it's either a person or a non-person based upon the guidelines and
Yes.
how it's designated. The
Yes,
problem we run into is when it wasn't designated pre-1993 and how we handle that. You can't change a person
That's
or
correct.
non-person designation.
So
Yes.
classification is black or white, person or non-person for the
Af-
pre-93.
after 1993, yes. Yes. I'll make one last point and I'll sit down here. I just asked this court to think about this for a moment. Why did Keel overrule Williams? Why did it see the need to overrule Williams? Is that because of the target date? Or is that because Williams did something that triggered Murdoch 1? Well, Murdoch 1, you said was wrong in Keel. Williams, for some reason, was also wrong. What was that reason? And then I think we have answered our question. And that's the point I wanted to make, and I apologize for being cavalier. I'm not trying to be, but I can see that we have a bit of a division in the court for a reason. And I think now you guys get to slug it out. Thank you.
Thank you, Mr. Dash. Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement. To explain to our visitors and others about what we mean by that, the court will later today conference this case. And I don't know that we will slug it out, as Mr. Dash said, but I'm sure we will, it sounds like we'll have a spirited discussion. But after that, one of the justices will be assigned to draft a decision in this case. That will then be reviewed by, once a draft decision is prepared, that will be reviewed by all of the rest of us. And we will continue the back and forth and ongoing discussions about the outcome and how we explain that, how we reach that outcome, because that is one thing that is different in terms of how this branch of government works versus other branches of government, in that we do write out the reasoning that leads us to a decision. And that is available to you and will be published online at kscourts.org. A news release will be issued when that happens to help give some information or some notice to you that it's now time to go look, and you can find that opinion online. Before we adjourn, Mr. Skeen, would you like to come forward and introduce your group?
Please the court. My name is Alan Skeens and I am from Blue Valley School District. These are my law and public safety students. They're seniors in high school. And they're in the CAPS program, the Center for Advanced Professional Studies. And we appreciate the opportunity for especially letting this come in and why someone was up there talking. So we had buses. We usually try to get here on time and just like everyone else, not enough bus drivers. So they couldn't pick us up till they made their morning delivery. So thank you for having us.
Everybody.
You weren't here yesterday, but yesterday we had some high school students from Topeka West. And Justice Rosen is an alumni of Topeka West. I am not an alumni of a Blue Valley school, but all of my children, 6 children, went through the Blue Valley schools, and I have one currently at Leawood Middle School who will be going up. So, and I live in the Blue Valley School District, and so I'm extending a very, very warm welcome as a neighbor.
Thank you.
With that, court will be in recess until 10:30.